Good afternoon, everyone. Good afternoon, my dear panelists for today. And good afternoon, our dear participants. We will allow more people to join for about 5 minutes, and then we will be able to start.
Patience, are you muted?
Yes, Charles, I was muted.
Sorry.
Good afternoon, Charles. How are you?
Good afternoon.
So it's 5 minutes past 2. I can see we have a good number of participants who have joined us online. And I'll give it just 1 more minute, and then we'll get started. Good afternoon once again. I hope we are all enjoying our Friday. Thank God it's the start of the weekend. My name is Patience Akampura. I have the pleasure of hosting today's webinar, and I would like to thank you for taking out time of your busy schedules to join us today. And we are confident that you'll find today's discussion fruitful. We are confident that you'll find today's webinar insightful and fruitful. And we hope at the end of the go out with 3 or more principles to apply in your. I have the privilege of moderating. I have the privilege of moderating today's webinar. Today's webinar is called Principles of Construction Adjudication. It's a webinar that has been organized by the Chartered Institute of Arbitrators, Uganda chapter. And I will be moderating this webinar with 3 seasoned gentlemen who are professionals and practitioners in the industry. And I believe by the time we finish, you'll have the same sentiments. But before we start, and before I introduce my panelists, I'd like to remind you about the inaugural Chartered Institute of Arbitrators International Arbitration Conference. This is happening this year in Uganda. It will be taking place on the 13th of November to the 14th of November. It will be happening at the Mistil Hotel in Zambia, Kampala. We're going to share the details, the flyer in the chat, as well as the details for registering. Kindly take part in this conference. And in case of any further information, please feel free to contact any of us and we'll give you the relevant information. So without further ado, I'm going to go ahead and introduce the panelists. But before I do, I hope you can all hear me clearly. Please just, send a message through. Let me check with the panelists. Charles, can you hear me?
Yes, I can hear you loud and clear, Patience.
Thank you very much. Good afternoon, Albert.
Good afternoon, Patience. How are you?
I'm fine, thank you. Good afternoon, Joseph. How are you?
Patience, I'm okay. And yes, can hear you loud and clear.
Perfect. So I'm going to go ahead and introduce our 3 panelists. I'm going to start with you, Joseph. So the first panelist is Mr. Muleba Joseph Chitupila, partners of Jill and Seth Advocates. He has practice of over 15 years. He has an experience of practice of over 15 years in the Superior Courts of Zambia. And so he has also practiced in South Africa and Kenya. Joseph is a notary public and a fellow of the Chartered Institute of Arbitrators. He is also a member of the African Arbitration Association, the African Construction Law, and the International Council for Commercial Arbitration. Mr. Muleba holds a Bachelor of Laws degree from the University of Zambia. He has a diploma in construction adjudication from the Royal Institute of Chartered Surveyors, South Africa, and he also holds a master's in taxation from the University of Pretoria. Mr. Muleba's practice mainly focuses on dispute resolution, wherein he has handled several matters in arbitration, construction adjudication, transactions, and as well as finance. He is currently the Honorary Secretary of the Chartered Institute of Arbitrators, the Zambia branch, and he has also served as the chairperson. He has previously served as the chairperson of the Young Members Group of the Chartered Institute of Arbitrators, Zambia branch, as counsel and as arbitrator with the Lusaka International Arbitration Center. Thank you, Mr. Muleba, for joining us and taking time off your busy schedule to be part of this webinar.
Thank you, Patience. I'm looking forward to it.
Wonderful. Next, I will introduce Mr. Charles Gavamukulia. Charles is a civil engineer, a construction contracts and claims specialist. He's a certified professional mediator, adjudicator, and arbitrator, as well as the member of the Chartered Institute of Arbitrators. Currently, he is the chairperson of the Young Members Committee of the Chartered Institute of Arbitrators, Uganda chapter. Charles holds a Master's of Science in Construction Law and Dispute Resolution from Leeds Beckett University, United Kingdom. He has a Bachelor of Science in pursuing another Master's in Civil Engineering at Makerere University. Currently, he is the Executive Director of CG Engineering Consults, a reputable firm that specializes in construction contracts, claims, construction law, and dispute resolution, as well as design. Charles has advised on several aspects of construction projects, from the initiation process up to the post-contract in very many standard forms of contract. And he has also contributed to the academic discourse of construction law through various publications. His publications have been published in the European Journal of Applied Science, Engineering and Technology and the Journal of Conflict Management and Sustainable Development. Thank you, Charles, for joining us today.
Thank you very much for having me. Pleasure to be here, Patience.
All right. Lastly, but not the least, Mr. Albert Mukasa. Albert Mukasa is an advocate of the Courts of Judicature in Uganda. He holds a Bachelor of Laws degree with honors from the Makerere University School of Law and a diploma in practice from the Law Development Center. He also has a diploma in international construction contracts from Paris University Pantheon. He is currently the managing partner at M&K Advocates, where he heads the dispute resolution team, and he is also a fellow of the Chartered Institute of Arbitrators. He has acted as a sole wing and presiding arbitrator in several disputes, and he was also a former ICC representative for Africa, during which he organized several events to promote international arbitration across Africa. In 2025, Mr. Albert Mukasa was recognized by the African Construction Law Institute with an award for his contribution to construction law in East Africa. Mr. Albert Mukasa has been chosen as a Chevening Scholar for 2025-2026 to pursue his master's in construction law and dispute resolution at the prestigious King's College, London. Welcome, Albert.
Thank you, Patience.
Okay, so let's get started. And maybe before we do, I will encourage the participants, our dear participants, please, as the webinar goes on, share your questions, your queries and clarifications in the chat, and we're going to have a Q&A session after the webinar, and we'll endeavor to address all of them. Thank you very much. So I'm going to start with you, Charles. As you will recall, we have previously had trainings and webinars on principles of construction law and different ADR mechanisms. But today, we are interested in adjudication. So I'm going to start with you. Briefly, can you tell us what is adjudication as a dispute resolution mechanism in construction law practice?
Yes, so we have the what we can call the continuum of the arbitration dispute of the alternative dispute resolution mechanisms. And what we mean by ADR, maybe for those who are attending and want to be brought on board for the first time. So ADR, that is alternative dispute resolution, are these mechanisms that involve resolution of disputes outside the courts of law. So that is outside litigation. And of course, they involve mechanisms such as negotiation, mediation, adjudication itself, early neutral evaluation, expert determination, arbitration. And adjudication is very interesting because it is one of the first times where a third-party neutral gets involved in the actual resolution of the dispute. So with adjudication, you have a third-party neutral, that is to say the adjudicator, coming in to resolve a dispute between parties, and normally this is done in the construction industry. So what we have is a decision at the end of the process, and this decision is normally referred to as a temporarily binding decision. And why this is the case is that in case one of the parties expresses dissatisfaction with the adjudicator's decision, then this dispute can proceed to be resolved by other dispute resolution mechanisms such as arbitration or litigation. However, as we shall see, in jurisdictions where this has been properly applied, the King's College London report on construction adjudication, for example, in the UK, where adjudication is a main staple in the construction industry, indicates that majority of the parties are actually satisfied with adjudication as a dispute resolution mechanism. They are satisfied with the decisions that are made by the adjudicators, and therefore about 92% of the cases do not proceed to arbitration or litigation, whatever the case the parties have stated in the contract. So it is an interesting dispute resolution mechanism. Of course, it requires someone to be a bit knowledgeable about it and know exactly what to do, most especially if they are the adjudicator, the third party neutral. But I suppose it's one of the reasons as to why we are here for this webinar. So I'll give it back to you. Yes.
Thank you very much, Charles. Now, I'm going to ask Joseph to briefly tell us, Charles has talked about how the dispute resolution of adjudication is a temporary mechanism. That's one. But he has also spoken about other dispute resolution mechanisms like arbitration and litigation. And now I would like to go over to you, Joseph. Why should a party opt for adjudication when the dispute arises in a construction contract?
Thanks, Patience. So I think in answering that, you need to set a bit of a scene. Okay, so when you're dealing with adjudication, naturally it's coming out of construction contracts, right? So you would find that it could be a construction of a road, could be construction of buildings, bridges, residential buildings, commercial buildings. And what you then tend to find is that a lot of money goes into such construction projects. And you can imagine sometimes it could be government who wants to quickly build a hospital and set up their roads. So you don't want to get tied down in delay and say this. So that's why now you say, okay, fine, what's our most quickest dispute resolution that could help us achieve quick conclusion and finalization of these projects, construction projects, which is where I think adjudication comes into play. Now, what advantages does it have over arbitration and litigation? I think I'll just want to quickly point out four. The first one being time. When you talk about adjudication, the time frame involved for an adjudicator to hear and determine a dispute are relatively shorter. Because of this, there's this common phrase we hear, when you're in the construction industry, of what we call rough justice. So it's called rough justice because the timeframes are so short, but the idea is that in that short time frame, you have your dispute brought forward. Each party will get a chance to present their case. Then the adjudicator has to then give his decision. So for instance, I think if you look at the various contracts, the FIDIC contracts, we'll discuss these in detail as we go along, the FIDIC, the JBCC, there are certain timeframes involved. So you can pick up, I think in FIDIC, you're talking about 28 days, 84 days, JBCC here as well, 7 days, 15 days. So there's quite a bit of speed about that, which is one advantage. The second one, I would say, is the cost, which is slightly related to the first one, in that, and I can give context for that practice, sometimes in litigation, arbitration, and adjudication. So litigation, on average, you're talking of a minimum of 2 years to have a dispute heard and resolved. And then even after the first hearing, there are issues of appeals, which tend to take it to 2 years, 3 years, 4 years. Arbitration as well is not as fast as adjudication, so it also takes a bit long. So adjudication comes back to the point of being quick. So when something is quicker, it means also your cost associated with it is lower, because then you're going to finish the hearings quicker. So you're not going to extend a lot in terms of paying your lawyers and generally delaying the project overall. So you also have the adjudication is cost effective. The third one, and I think this one's crucial, is that you have expertise. When you're dealing with an adjudicator, and I think Charles mentioned this briefly, is that you'll be given, as parties, you select an adjudicator who is qualified for that particular dispute. Contrast that with, for example, litigation, where I'm not sure about the scenario in Uganda, but in Zambia at times, when you have a dispute, you just be allocated a judge, not so much about their expertise. Okay, so now you can imagine, do you want a construction contract being determined by someone who does not have that particular expertise and qualification? So when you have an adjudicator, though, on the other hand, is that you'll be having someone who is specifically appointed by the parties, but crucially, who has the qualifications around what you need, so they're able to give you a good quality decision at the end of the day. Then lastly, I would say is the advantage is that the decisions of the adjudicator, again, Charles mentioned this briefly, and we'll look at it as we go along, but the decisions once made are immediately enforceable. Okay, and I think that's crucial because let's say, for example, it's a dispute that's where money is tied down. You want a decision quickly, and maybe party A is then said, look, you are entitled to X amount, and you'll then be entitled to get that payment immediately. That allows you to unlock payment for the rest of your project. Okay. Now, compare that to litigation where a decision may be made and then there'll be an appeal and then you can get a stay of the decision. But for adjudication, you're saying, look, you have a decision of the adjudicator, enforceable immediately, even if you want to escalate to arbitration and litigation. But the point is, it's immediately enforceable. So those are the 4 immediate advantages, I would say. And, if you're dealing with construction projects, adjudication is the way to go.
Yes, I totally agree with you. Thank you very much, Joseph. And like you've said, the situation is the same in Uganda. You file your matter in court and it will be allocated to whichever judge is available or based on the scheme they use. So yes, rightfully stated, adjudication, you get to decide. Now, from what you said, what I'm hearing is that this is a very speedy process. You mentioned 28 days, 7 days. So which then means the parties that are involved need to be time cautious and you don't have time, to play around or to start selecting that specific adjudicator that is going to handle the matter. And now I would like to move over to you, Albert. Based on the speedy nature and the requirement for expertise, I would like you to tell us briefly, at what point should one appoint an adjudicator? And also in appointing one, what considerations do they have to bear in mind?
Thank you so much, Patience. And starting off from what both Charles and Joseph have highlighted, adjudication by nature is an interim decision-making process. Therefore, it is quite important that a decision is concluded in the shortest time possible. So at the time of when the adjudicator should be appointed, it is important to go back to the contract or the statutory framework. We have countries like the United Kingdom that have a statutory framework, or Australia, and recently Hong Kong. So you look at what the contract talks about the appointment of the adjudicator. If it says 14 days from the dispute, then the appointment should be done within that time. If it is a contractual framework, then you have to follow the contractual framework. You have to follow the contractual framework. So it is important that you follow those provisions. When it comes to key considerations why you should, when you're choosing an adjudicator, I would give an example in Uganda. The adjudicator, just give me a minute. Just give me a minute.
Joseph, I'm going to come back to you as we wait for Albert to return. Just briefly, you mentioned that adjudication is cost effective, and we all know that the construction industry, highly or all the time, cash is the bloodline. Without the money, you need to keep, you can't continue with the works. So I would like you to shed some light briefly on how cost effective is it? I know you said, if you compared it with litigation, but I'm looking at it from the angle of it's the parties to the contract that are appointing these adjudicators. So maybe briefly, you can just shed some more light on how cost effective it is, so that a party is well aware that I am getting into this mechanism and I'm going to have this in respect of the costs.
I see. Okay. How can I give it as an example? So maybe, just briefly whilst waiting for Albert. So, like when we spoke of litigation, right? And I'll give you the context of Zambia. So in Zambia, you'd have your first level being the High Court. Okay. And then if a party is unsatisfied, then they go to the Court of Appeal. And then if you're able to get leave, you go to the Supreme Court. So you can imagine at each of these stages, you'll be paying lawyers to represent you. Okay, so that's High Court, Court of Appeal, and then possibly the Supreme Court. And like I said, this could be over a period of 2 years, and then if you continue escalating to the Court of Appeal, Supreme Court, so it could even be 8 years So you can imagine for 8 years, you will be paying legal fees to your lawyers. Whereas in contrast with adjudication, it will be over a short period of time. So let's just say theoretically 1 month, 2 months, you would have fine, you'd still pay your representatives, but the cost you'll be paying there will be far much less than when it's escalated over the course of a period of litigation. And like I said, also sometimes you look beyond the monetary side of things. If you have a dispute tied in court, I mean, you're also losing time. And then time then means the project won't be finished. The project won't be finished, meaning you won't get paid. And there's so many, the cost goes beyond the finances, but goes to time and it stretches. You won't get your hospital, you won't get your development. So there is that aspect of time in terms of the cost, in terms of both financial and what I would say spans beyond the finances. Yeah, I see Albert is back.
Thank you very much, Joseph. And maybe also what I'm hearing from you is the fact that you're able to have this dispute resolution mechanism in the shortest time possible while your project is ongoing, which means there is very minimal interruptions with the project. So thank you very much, Joseph. Albert, I'm going to come back to you now. You are going to take us to the key considerations that parties should bear in mind when they are appointing an adjudicator.
Yes, apologies for the earlier mishap. Now, when it comes to key considerations for choosing an adjudicator, you want to ensure that your adjudicator is impartial. So it's very, very important, especially if it comes to a referring party, the party who claims that a dispute has arisen, to determine the choice of adjudicator is impartial and independent. When it comes to Uganda, since we do not have a statutory form of adjudication, in most of the public projects that we have, the clause indicates the Uganda Institute of Professional Engineers has the mandate to appoint the adjudicators. And in most cases, when you make a request to them, they share a list of potential adjudicators from which you have to make a choice. Now, depending on the names shared, you are able to tell whether an individual has worked on a project on which you are on, whether the individual is actually a subsisting client, and whether an individual is even a shareholder in one of the parties or maybe the contractor. So it is important that you look at the independence and impartiality both from an actual and perceived angle, and then you're able to make a choice. Secondly, expertise. As we mentioned, adjudication has been mostly used in construction projects, which is quite important because it relies heavily on the expertise of the adjudicator. In most cases, before the adjudicator is appointed, the project manager or the engineer who is in charge of the project would have made a decision. Now, in order to either confirm that decision or to reverse that decision, then the adjudicator comes into the picture. So it is important that the person who is appointed has the technical expertise to make determination. It could be an issue of variations, it could be an issue of a payment order, and you want to make sure that the person who is going to make that decision has the necessary expertise. When it comes to the third element, I would say is experience. How many adjudications has this individual done? What forms of contracts have they adjudicated upon before, and the track record? And usually you may not have a formal advert which is placed in the newspapers or somewhere, but at least this information is available. For instance, if you go to certain institutions like UK adjudicators, you're able to get a full set of information about a particular individual. What contracts do they have experience in? How many have they worked on in that? But if it is FIDIC, how many FIDIC disputes have they handled in that regard? Fourthly, and I would say usually this is overlooked, the issue of availability. If you choose an arbitrator an adjudicator, apologies, an adjudicator who is very busy, it means the whole essence of the adjudication process gets lost because this individual will not be able to deliver the decision in time. So it is important that the adjudicator is available and is available to deliver a decision within a timely manner. The other issue concerns administrative practicality. Are you able to deal with an institution? For instance, I mentioned Uganda Institute of Professional Engineers. How easy do they make it for you through the entire process of appointment? How soon do you get the names of the potential adjudicators? How soon do they respond to administrative issues concerning fees and related issues? So you have to be sure that, when you make a choice or you are looking at making a choice of an adjudicator, all this come into play. And then most importantly, when it comes to jurisdiction, what are you looking at? What is the permit of the adjudicator within the contractual framework? What are they supposed to do? And in the end, where the decision is going to be made, does the jurisdiction itself recognize the adjudication decision to be enforced either as is or through arbitration or litigation? And so for me, I would think those are the key considerations that a party who is seeking to make a decision or on who to appoint, where to make a decision, whether you need an institution to appoint from or you have to make an ad hoc appointment. This becomes very, very important for you at the back of your mind. Some of it, if you choose an institution that is already, like, for instance, RICS is a recognized institution, the Royal Institute of Surveyors. So they already have rules on appointment and everything else. So it is important when you make that decision, some of those things are available for you as guidance on how you go about the process at the time of choice. But most importantly, does the arbitrator are they impartial? Do they have the requisite expertise? And then do they have the experience? So, Patience, I would think that would be what you would look out for.
All right. Thank you very much, Albert. Now, before I let you go, I am briefly in 2 minutes. I am going to ask you, you mentioned that Uganda does not have a statutory framework for construction adjudication. And I want you briefly to touch on if they don't have the legal framework, what form do they take? And you made a slight mention of standard contracts. So I'd like you briefly to shed some light on the form of adjudication that is taken on by Uganda or other jurisdictions where they do not have a statutory framework.
So thank you very much for that question. Like I mentioned, Uganda doesn't have a statutory form of adjudication. So the adjudication that is applied is contractual adjudication, meaning that this stems from the contract. So we could look at it both from a domestic and an international perspective. Domestic being the local contractual framework that is usually used, especially for public projects. So in this regard, we have the public procurement and disposal of assets framework, contractual framework for works. Now, in this contractual framework for works, there is a general contract, which in most cases is adopted through the public procurement process for works. So in this framework, usually I think it's clause 24, 25, depending on the version, provides for adjudication. And in most cases, this clause is agreed upon also in the special conditions of contract. And usually it provides that, in the event the project manager or contract manager makes a decision, then the party dissatisfied with the decision shall refer it to adjudication. So it comes from the contract itself. And usually after adjudication, of course, it talks about that in the event you are dissatisfied with adjudication, you go for arbitration. In the recent contracts, it has been litigation. Now, that being the case for the domestic ones, on the international side, because some of the major or mega projects that are handled in Uganda are funded by the multilateral development banks. Most of them have an understanding with the FIDIC organization, which has standard forms of contracts, be it red for construction, yellow for design and construction, and the EPC contract, which is also known as the silver book. So when it comes to the provision of adjudication, in that regard, usually the FIDIC contracts will talk about DABs, which are a variation of adjudication. We have the 1999 version. They talk about the dispute adjudication board. And then when we come to the 2017 version, we have the dispute avoidance and adjudication board. So when it comes to how we relate them within the legal framework of Uganda, we look at them from a contractual side, because these are forms of contracts. They are not legally binding legal instruments, but however, they are binding contractual frameworks on which the parties have agreed to be bound by. So as we speak in Uganda, we do not have, but Kenya has a bill which has gone through, I think, 2 readings of Parliament about construction adjudication, known as the Construction Adjudication Bill, which is supposed to deal with some of these aspects of construction adjudication. Because there are certain instances where parties that they do not know about adjudication, they do not include it in their contracts, or even if they did include it in their contracts, they do not know what to do once the clause has been triggered. So it becomes a bit of a challenge that they don't know what to do with the process, if I may put it that way. So statutory adjudication comes in to deal with some of those issues that the statutory right to adjudicate is now legislated upon, and it becomes part of the national laws. And therefore, even if parties do not have it in their contracts, they can rely upon it. So I would think maybe that gives you a bit of context of what we have. Maybe the country that I would highlight, and maybe someone else will add on this, the UK has a proper legislative framework. The law is known as the UK Housing Grants Construction and Regeneration Act of 1996, with amendments here and there, which provides a proper framework of how adjudication will be handled from a statutory angle. Thank you.
Albert, I'm going to have to stop you there. Yes, thank you very much. I was coming for you. Charles, just pick up from where Albert has talked. Our statutory legal framework for construction adjudication. Albert has already given you the introduction, so please take us to that. Also, I'm going to ask you to be brief in about 2 minutes. Please tell us about statutory adjudication. I know, yes.
So Albert correctly notes that adjudication is divided into 3 types of adjudication. So we have statutory adjudication, which I'm going to talk about. We have contractual adjudication, which Albert has talked about, where adjudication is a creature of contract, which we normally have here in Uganda with the PPDA forms for domestically and internationally with FIDIC. And then we also have ad hoc, where parties, when it's not a creature of contract, it's not a creature of statute, and then parties can just agree to have adjudication. So the UK is one of the countries that have statutory adjudication. So maybe for my people from the built environment, statutory adjudication means that it is an instance where adjudication is a creature of the law. So there is an act in the UK that governs adjudication and makes it mandatory for all parties to construction contracts to use adjudication as a dispute resolution mechanism. So maybe we can look at the origins of this, which are very similar to what we are facing in Uganda right now in the built environment industry. So in the 70s and 80s, the construction industry in the UK was very volatile because of a number of reasons. And this volatility was leading to contractors winding down, which we are also seeing here in Uganda. And some of these reasons included disputes regarding defects, variations, valuations for the IPCs. And then there was also cross claims. So what would happen is when there was an IPC, the employer could make a cross claim, and in that instance, they wouldn't be able to make payment to the contractor. And remember, we say that for the construction industry, cash flow is king. And therefore, given the fact that the contractors were starved of cash flow, this led them to really struggle in the 70s and 80s. Of course, there's that key case, Modem Engineering Limited and Gilbert Ash. Someone could look it up. It's one of those cases that even overruled some other case that had allowed for no cross claims. So in Modem Engineering Limited and Gilbert Ash, the courts had actually agreed that employers could actually make cross claims. Of course, because the construction industry in every country is a significant contributor to the GDP, in Uganda here we have it to about 8 to 12%, which is similar to the UK. It was found that it was important for this industry to be healthy because it was an important cog in the wheel of the economy of the UK. As such, in 1993, Sir Michael Latham was commissioned to look at the procurement and contractual arrangements in the construction industry in the UK. And in his report, which he called Constructing the Team, he came up with 30 recommendations. But the most important recommendations for this conversation is recommendation 25 and recommendation 26. And those dealt with issues regarding payment and issues regarding the resolution of disputes. And the law, which was later on enacted, the Housing Grants Construction Regeneration Act of 1996, which came into force in 1998, it actually resolves both those issues. So the law, the statutory adjudication in the UK, the law itself, if you look at the act, part of it deals with payment, part of it deals with resolution of disputes. Of course, with this, it meant that parties were meant to resolve disputes as soon as possible, such that they could get out of the way and such that, construction projects could go on. Of course, this HGCRA was later amended by LDEDCA, the Local Democracy, Economic Development and Construction Act of 2009, which also came into effect in 2011. So what's special about the HGCRA is that in section 104, so section 104, defines what a construction it's termed as a construction operation, what a construction operation is. So if a contract falls within what is defined as a construction operation, then by law, it is mandated that it should use adjudication as the dispute resolution mechanism in the first instance. And of course, it proceeds in section 105 to make exclusions on what is not a construction operation. And of course, what is key about the adjudication or the statutory adjudication in the UK is that it provides for resolution of disputes under the contract, meaning it bars resolution of the non-contractual disputes such as things regarding misrepresentation, actions in tort, which FIDIC allows, but the statute, the one in the UK doesn't allow for that. And of course, an adjudication can be brought at any point during the contract or even at the end of the contract. We should note that there are other jurisdictions that have statutory adjudication, I think, as Albert noted, like Australia or Canada, but the application of these statutory adjudication regimes is a bit different. So that of Australia or that of Canada is what we call, or what is called the security of payments legislation. So for it, it only deals with disputes regarding payment. only disputes regarding payment, other contractual disputes, disputes regarding interpretation or things like that can be resolved by other means, so maybe arbitration or litigation. So that can be the significant difference between the statutory adjudication regimes and how they're applied in different parts of the world of occupations.
All right, thank you very much, Charles. Well said. Now, going to Joseph, the beauty with such webinars, you have people from different jurisdictions. So, Joseph, I would like briefly to tell us from a practical perspective in Zambia, how you've dealt with the statutory, whether you have one, or the contractual or the ad hoc, just briefly before I can take you to the next question.
All right, thanks. So just very briefly, Zambia pretty much mirrors, I would say, the larger part of Africa and the world. I mean, very few countries have statutory adjudication. So we do not have statutory adjudication. Good news, maybe badges, good news more, is currently the bill, we have the Arbitration Act in Zambia is being reviewed. And one of the elements which is being thrown in is adjudication. So once we get this new bill sorted out, we will then join the select few countries who have statutory adjudication. So then briefly, since we don't have that, what do we have at the moment? It goes back to, I think, what Albert covered quite at length, which is contractual adjudication. And obviously you find that through, for example, the most common one is FIDIC, Red Book, Yellow Book, Silver Book. And that also is mirrored because, in Zambia, we have a number of these multilateral institutions who fund projects, and their preference is to use standard documents and standard contracts, which takes us back to FIDIC. And then obviously, through those contractual documents, you then have your setup of adjudication. And of course, lastly, yes, we also do have the ad hoc side. So you could have parties who've gone into a contract who did not provide for adjudication. It's construction contract, they've now run into trouble. Then they do it by ad hoc, simply agreeing amongst themselves, okay, fine, let's go for adjudication. These are the steps we'll take, appointment of adjudicator, timeframes, and whatnot. So in summary, Zambia statutory adjudication at the moment, no, but it's coming. In the meantime, what do we use? Contractual and ad hoc. Yeah.
Thank you very much, Joseph. We look forward to hoping that you will pass the amendment for your Arbitration Act and we can pick one or two leaves from there. Now, Joseph, I'm going to still stay with you on this one. We have had, we have to appoint adjudicators, taking. So now I would like you to tell us briefly, what is the nature of the claim or a dispute? What am I bringing before an adjudicator to determine? So I'd like you to tell us what is the nature of those claims or disputes and what is maybe going to be dealt with at a time when I am going before an adjudicator.
Okay, so I think the starting point, Patience, is do you have a dispute? Okay, so even before you say let's approach an adjudicator, let's approach nominating bodies, do you have a dispute? That's very crucial because if you don't have a dispute, you'd be wasting your time going for that. So the first question is, do you have a dispute? And a dispute would have to have, you use the word crystallized between the parties. Okay, so obviously mine is a legal background. So I'll just refer to two cases where they just briefly give us an idea of what a dispute is. So the first one is, it's a case titled Fast Track Contractors Limited versus Morrison Construction Limited, 2000. It's from the UK. And they had said a dispute can only arise once the subject matter of the claim, issue, or other matter has been brought to the attention of the opposing party, and that party has had the opportunity of considering it, admitting, modifying, or rejecting it. Okay? And then there's, of course, the most celebrated and more known case, which is Amex Civil Engineering Limited versus Secretary of State for Transport, where they had considered a number of factors. But in summary, even they had said, look, mere notification of one party to the other of a claim doesn't amount to a dispute, but the claim must be made, and in that dispute, the claim must either be disputed or modified. Then that would trigger a dispute. Then how do you also, when you make a claim, how is it disputed? So a dispute, I could expressly say, Patience, we received your claim and we expressly reject it. Or you could also have a dispute where one party is either silent when a claim comes through, or maybe they just simply by conduct, they're not responding to you, and then you're able to infer that, okay, we now have a dispute here. So that's the first crucial step, which is there must be a dispute which has crystallized, and then that's what now allows the aggrieved party to then trigger the notice of referrals, and then the other party responds, and you then get your processes started. Then just briefly, what's the nature of the disputes? Look, the common ones you find are maybe liquidated damages, where the project is running late, so there could be a dispute or a claim around that. A claim for payment of works. I always find this one funny, because if I've worked for you, patients, you must pay me. But you always find that, okay, claim for payment. Where there could have been additional or variations of work on the contract, and there's a dispute around that. Another crucial one is poor workmanship or defects. Usually you would find disputes around that, and those must be dealt with, I think, before the project comes to an end. And maybe lastly, there could also be disputes about extension of time. And when you talk about extension of time, obviously you then have issues of losses and expenses because you're extending time. So there may be disputes about that, where you say, look, because the project has been extended, I've incurred additional costs of X, and then I want this amount of money. The other party refuses, and then you're in a dispute, and you'd have had your claim. So just ever so briefly, I would say that is it. You'd have to have your dispute established, that there's a claim, there's a dispute, it's crystallized, it's triggered, and then after that, various types of disputes you have. And just lastly, I would say is that who can then trigger this, this whole dispute process? Remember, in the contracts construction, you have the project manager, the contractor, those players in the contract. Those are the ones who trigger the disputes and the claims. So, for example, a party who is not part of the construction project can't come and say, "Oh, I want a dispute here. I see a dispute." So, for now, when we talk about disputes, we're limiting it to these parties in the construction contract.
Thank you very much, Joseph. And I think the last point you've made is an important one, because if you're not party to the construction contract, then you have no audience, or you have no business in bringing this adjudication proceedings. Now, I'm going to go to Albert. And Albert, briefly, we have where and it being cost effective. But we also talked about expertise, and adjudicate having expertise. Now, we all know that in the practice that we are, engineers, lawyers, architects, at the end of the day, you need money here and there. So my question to you is briefly, what does the scope of an adjudicator's jurisdiction look like? What is their scope? Also, what powers can they exercise? And more so, I would want you to touch on the powers that are in respect of the adjudicator, but also the parties, just briefly in 2 minutes. Thank you very much.
Thank you very much, Patience. Maybe just before I respond to that question, the issue of scope and what amounts to a dispute. There's a recent decision from the English TCC, which is the Technology and Construction Court, where they had to determine where the dispute crystallized after 20 years. And not only was it focusing on the construction contract, but the party went ahead, also looked at breach of duty under their legal regime called the Defective Premises Act. So when it comes to the dispute, depending on how the court looks at it, it could go beyond what would be a contractual breach. It could also go into other spheres. In this case, they went to the Building Safety Act. And of course, the respondent opposed vehemently and said that the adjudicator at the time did not have jurisdiction to determine a claim made under this Defective Premises Act. And then, of course, cried about a breach of natural justice, that the time lapse had been such a long time. 20 years was a long time. But the court rejected both claims, saying that the adjudicator had jurisdiction because of the nature of the contract they had signed, which allowed all sorts of disputes to be determined, including those that may not necessarily be under the contract, and treated the clause as a one-stop dispute resolution forum. So in other words, adjudication would determine each and every dispute that has been brought before the adjudicator. On the issue of breach of contract, the court said that there was no breach of contract and emphasized that it was merely poor record keeping on the part of the respondent. So it is important to also look at that clause. What does it say in terms of the scope of the dispute? So that you are able to know whether you are only looking at disputes that arise within the contract itself or those that can arise without, like tortious claims. That in this case, it was bordering on tortious claims. Now, back to the question on what would be the adjudicator's jurisdiction and powers. Of course, like I've mentioned in the previous answer, it still goes back to what does the contract provide. So you have to know what powers does the contract give you, which disputes can you handle? Are you only handling payment disputes? Are you handling other disputes other than those that would, for instance, time extensions, design deficiencies, contract interpretation, things of this sort. So it is important to go back and understand the clause that is the parties signed for, and how extensive does it provide in terms of scope in case of a dispute, because it goes back to what Charles highlighted, that in some jurisdictions you have a proper framework which talks about construction adjudication. In other jurisdictions, they're talking about security for payment. So that alone tells you what the scope in each of those jurisdictions is when it comes to the adjudication that arises from such a place. When it comes to scope and why and the powers that you have, like I said, it comes from the contract, but also you need to look at and say, okay, if the contract has provided that RICS will be the appointing authority for the adjudicator, RICS has rules, adjudication rules, which it applies. What do those rules provide in terms of what the adjudicator can do, especially where the contract is not extensive in terms of providing for the powers and jurisdiction of the adjudicator. So, and most importantly, are these powers compatible with the governing law of the country? You do not want to have a scenario where, if you read the FIDIC contract, one of the things they mention is that adjudication is not arbitration. So in other words, even in the exercise of the adjudicator's powers and jurisdiction, they have to do it in such a way that they do not assume the position of an arbitrator. So with that, I would also highlight maybe going back to the law and looking at it in terms of what the law provides when it comes to the adjudicator exercising their mandate. Thank you, Patience.
All right, thank you very much, Albert. Just briefly, I have a question that I would, a follow-up. It's in respect of costs. Who determines, for example, if you have an adjudicator, who determines his expenses for the process? And then also I will go to Joseph in respect to the same. So who determines the adjudicator's expenses for this process that is taking, and who bears the cost? Pro bono, not pro bono really, because courts parties don't pay. So how are they dealt with in adjudication?
Yeah, just to give you a straight answer, when you look at the PPDA form of contract for works, it says the adjudicator shall be paid, I think, a sum of 500,000 per day, and this cost shall be borne by both parties in equal installments. So that in itself tells you that a contract is one of the sources of this cost. Then also, like I mentioned, rules provide how the payment of the adjudicator is going to be done. Like the WICS rules are a good example. You could look at them and see how they provide the costs for the adjudicator. And the general standard is that this cost is usually shared between the parties, so that you don't have a scenario where one party feels that they're either being dragged to a dispute resolution mechanism, which they do not have skin in the game. So it is important that you look at it that way. Either it's by contract or by rules which the adjudicator is applying.
Thank you very much, Albert. Now I'm going to go to Charles. We have covered, who is an adjudicator, their powers, the processes that are going to be involved. As you have a dispute. Joseph told us what a dispute is and what it has to look like for you to actually have a claim, for lack of a better word, to bring before an adjudicator. So Charles, briefly, I would like you to tell us in the shortest way possible. Just take us through the adjudication procedure. Joseph has said you have a dispute, it has crystallized, which means now you need a remedy, and now you've opted for adjudication. How do you get there? What are the timelines involved? But I would like you to just briefly take us through the procedure.
Okay, thank you very much. Of course, the first step is for the dispute to crystallize, and as we said, there is a difference between the word dispute and claim. So the claim leads to the dispute. We don't take the claim to adjudication, we take the dispute to adjudication. And there are various ways as to how a dispute can crystallize, which have been tackled both during the contract and even post-contract for cases of latent defects or things like that, which Albert and Joseph have, explained. So firstly, the dispute must crystallize. And then second, if it's in the UK, the referring party then makes a notice of adjudication. So the notice could either go to the adjudicator nominating body, which could be Ciarb, which could be RICS, which could be UK, adjudicators, for the parties to get an adjudicator who, has to take over the adjudication. So what's important about the notice of adjudication is that what it defines as the dispute is the jurisdiction that the adjudicator will have to that is that dispute. It defines the dispute that the adjudicator will have to resolve, on which their decision is required. So that means that it's important for parties in their system to make sure that they, put some tact as they are trying to craft that notice of adjudication. And then, of course, after reception of the notice of adjudication, there could be appointment of the adjudicator in the statutory system. And then, of course, the adjudicator, one of the first tasks that they will do, of course, money and all those things can be agreed on. But one of the most important tasks they actually have is to set the timetable. So the timetable will mention when the referral, because remember, we already just have a notice. So the timetable can mention when the referral is expected from the referring party. So the referring party could be either the employer or the contractor. And then, of course, it will also mention when the response to the referral is expected. And normally, the referring party is given a chance to give a response to the response. And then if it's the statutory adjudication regime, a decision will be expected 28 days from the referral. But then the scheme allows for an extension, but the extension has to be based on the parties agreeing. So you will normally see that adjudications in the UK take about 28 to 52 days. So there's normally some extensions that are, done by the parties, most especially if maybe there was need for experts or things like that, and the adjudicator is unable to make a decision very quickly. Because remember, at the helm of this, we're supposed to remember that this is supposed to be in accordance with the legislation, which is meant to quicken the dispute resolution process. That's why it takes a short period of time. However, when we look at, say, the contractual regimes, I'll use FIDIC because I I tend to work a bit on more FIDIC contracts than PPDA. And I also have issues with PPDA and the crafting of the clause. So I will use FIDIC because it's better industry practice, in my opinion. So with FIDIC, normally, as Albert mentioned, regarding payment of adjudicators with FIDIC, the good practice is that there's appointment of the DAB, or what we call the Dispute Adjudication Board, 28 days after the commencement date. So the DAB is already on the contract. So therefore, when there's a dispute, so what happens in FIDIC contracts is there will be a claim made by the contractor or employer, depending. If it's a contractor, then that will probably be under subclause 20. And that claim would have to be determined by the engineer. So maybe that's under subclause 3.5 if it's 1999, or subclause 3.7 if it's 2017. So if the contractor is dissatisfied with the determination of the engineer, now that brings about the conditions that Fast Track and Morrison say, that I made my claim and the claim was, there was maybe acceptance of the claim partially, or it was modified, or there has been silence, so it has been denied. So that means that a dispute has now crystallized. So when the dispute crystallizes, there could be a notice of adjudication to the DAB, or there could simply be a referral of the dispute to the DAB. And normally what the DAB does is, after that notice is given, the DAB will also still make the timetable, giving time to the referral to be made, to a response to be made, to a response to a response. Normally, the FIDIC allows even, the employer to also make a response to the response to the response. So it's always, just trying to make sure that the parties have enough time. But of course, when these responses are being made, normally the adjudicator, both in the statutory regime and the contractual regime, the adjudicator can restrict what the response is to, because sometimes parties can take it to themselves to respond to everything, ideally making another claim or making another, referral, which normally starts to hamper the process, which is supposed to be quick. So after that, after the timetable is made and the submissions are made, then the adjudicator normally, in the FIDIC stance, would have to make the decision in about 84 days. So ideally, the times are shorter than what would be done, say, in arbitration or litigation, and that probably says why adjudication is probably a mainstay in the construction industry. So I think that's about it. That's about the process in both the contractual and statutory regimes. They are similar in some instances, but they could differ in some instances.
All right, thank you very much. Well said, Charles. Joseph, touching on the procedure, and more so after the parties have issued the referral or the notice, briefly, could you tell us practically from the Zambian experience or the other areas that you've practiced in, do the adjudicators, what type of proceedings do the adjudicators adopt? Are there times when it's oral, or is there a time when they simply take the documents that have been given and the submissions and they make the decision based on what is before them? Just briefly.
Okay, so part of that goes back to maybe what you would call party autonomy. And remember, adjudication is about speed. So you could have parties say, look, this is one that can be determined on documents only. You don't need to hear us speak. It's largely about calculations, quantum, engineering calculations. So then it's just based on the documents. So you make your submissions, the adjudicator will then look at the documents, and then he will deliver his ruling, his decision. Or alternatively, at times, there may be a need for oral hearings, depending on the complexity and if you need expert witnesses. So so you can have it both the actual oral hearings or just simply documents only, and then you extra fast track it.
Thank you very much, Joseph. Albert, back to you. So I have submitted my dispute. Let's take note, a dispute, not a claim, before the adjudicator, and they have given a decision. And we all know there will be a winning party and a losing party. And as the winning party, who is the referring party? How, my question is, how will they deal with the decision? In essence, how is an adjudication decision enforced by the successful party? Just in 2 minutes.
The nature of the enforcement takes various ways, because when you look at FIDIC, it talks about the parties going through a process of amicable settlement, and then subsequently, either party can refer the matter to arbitration. So for the successful party at that stage in time, the arbitrator is being sought to assist with the enforcement of the decision. In other words, the adjudicate has made a decision, however, the other party has not complied. We seek enforcement of the decision. And the other aspect is the parties could go for litigation for purposes of enforcement. And this has been dealt with by several jurisdictions, but one of them which comes to mind is Botswana. There's a case by the Court of Appeal known as the Botswana Mining Company, Diamond Company Limited versus Liftoff, where the Court of Appeal held that DAB decisions, or in this case, adjudication decisions, may be referred to the High Court for enforcement. However, the Court of Appeal added a caveat that, however, this should be done in exceptional circumstances. And exceptional circumstances it looked at the delays which were occasioned by the party maybe not complying with the adjudication decision, or the time and delays that were, especially in terms of appointment of the arbitrator or the other party not seeking the service, triggering the process of arbitration. And if you notice, in some contracts, parties tend to make the appointment of the adjudicator or even the arbitrator unilateral. In other words, it's only one party that can invoke the adjudication clause or can invoke the arbitration clause. So in that case, the court will be willing to enforce the decision directly. So it is either you go through the arbitral process to enforce, or you go through litigation. And in terms of jurisdictions that are progressive in nature, they've been able to enforce some of these decisions, notwithstanding the lack of a legal framework that would support this. They rely on the inherent powers of the court to do the enforcement.
All right, thank you very much, Albert. Dear participants, I would like to remind you that the cases which are being referred to by the panelists have been shared in the webinar chat. Please have a look at them and get the links for your reading at during your free time. And also keep your questions coming through. We are nearing the end of the discussion, but would like to address your questions at the end. Now, briefly, I'm going to move to Charles. You know, Albert has told us about the successful party, but now, as the party that has unfortunately not succeeded at the adjudication, under what circumstances or what grounds can that other party raise to challenge? I would like you briefly to give us three, as briefly as you can be.
Yes, so thank you. So there are different circumstances that can arise that can lead to a party challenging an adjudicator's decision. The first one is the easiest, whereby the parties try to challenge the fact that there was no dispute, because if you read majority of these, if you read the Act, the HGCRA, the Housing Grants Construction and Regeneration Act of 1996, it actually talks about a dispute, you know, if there is a dispute under the contract. So that could be the first one. In the statutory regime, the first one could be, is there an actual dispute or there was just a claim? So a party could say maybe there was no dispute, so that's one point. But even in the contractual regimes, if you read that FIDIC clause, which I think is sub clause 20.2 in 1999, it also talks about a dispute. So that means that in the first instance, there has to be a dispute. And the next one is about that particular word, if there is a dispute. So that means that adjudications normally, both in the contractual and the structure, they actually deal with one dispute at a time. So if two disputes are brought to the fray for adjudication, then the decision that is made, in my opinion, or in the opinion of the courts severally, is that it would actually offend the actual crafting or drafting of these clauses, both in the structure, both in the contractual and statutory regimes. But however, it's important for us to note that a dispute could have a number of sub-issues. So it could be a dispute about extension of time, but with a number of sub-issues as to why there must be that extension of time. It could be a dispute on money, but with a number of sub-issues as to why there is need for maybe additional compensation or things like that. So parties have to be very, very keen about whether there is a dispute and if it is actually a dispute. So that is one important thing. The other could be that those days before LDEDCA, before the act was amended, for example, in the statutory regime, parties could say that there was actually no contract in writing because the original requirement of the statute, the HGCRA, was that the construction contract should be in writing. However, with LDEDCA coming in force in 2011, there are instances where oral contracts, and we know because the English courts have severally handled this, how a contract comes into force, as long as someone can show that there was agreement, that there was consideration, intention to create legal relations, even if a contract is not in writing, even if a contract isn't signed, one could still argue that there is a contract, and therefore, despite the fact that it is oral, and since it falls within a construction operation, then parties could, use adjudication as a means of resolution of a dispute. The other could be if an adjudicator didn't follow due process, and probably this is very key here in Uganda, where adjudicators are not necessarily trained, where the metric of one being an adjudicator is that they're a registered engineer, which I vehemently disagree with. So it's common ground that sometimes adjudicators use arguments that weren't brought forward by the parties. So it's common ground that, for example, if it is about evaluation of costs, prolongation costs, parties could have used maybe Hudson's formula to calculate overhead costs. But because the adjudicator is much more familiar with Emden's formula and they believe that Emden's formula gives a better reflection or approximation of these, they actually apply Emden's formula ahead of what the parties actually submitted to them. It's common ground. It happens here. So, and also maybe if the parties were not given a chance to make their case, it also can happen whereby an employer, because of the power dynamic, makes their case, and maybe because the contractor is a small contractor, a local contractor, they are not given ample space or time to make their case by the adjudicator. All those could be issues that can lead to the challenging of a decision of an adjudicator. I think it can be very successful. Over to you.
All right, thank you very much, Charles. Now, lastly, I'm going to Joseph. We know the built industry has very many professionals. There are lawyers, architects, engineers, quantity surveyors, and very many. So I would like you to briefly tell us, and I would like this to be covered by both Albert and Joseph, but I'm going to start with you, Joseph. As a lawyer, and also because you've sat as an adjudicator as well, I would like you to tell us, what role does a professional, specifically for a lawyer, what role do we have to play in the adjudication process? And this is from not just the process, but in adjudication as a dispute resolution mechanism while dealing with your clients in construction projects or matters.
Thanks. So in answering this one, I would say we need to look at the bigger picture. Okay. Let's not get bogged down into sometimes technicalities around what has been claimed, what should not be claimed. At the end of the day, adjudication is trying to help us get the projects completed. Okay. So if you remember at the beginning, I prefaced by saying, look, governments will be wanting to build hospitals. They'll be wanting to build schools. That is the bigger picture we need to look at as professionals. And in getting those projects completed, hospitals built, getting our country developed, we will have disputes along the way. and education is coming to help us. So as we engage in adjudication, let's get our clients to understand that the ultimate goal is, look, there's a dispute here, which we quickly need to resolve, because at the end of the day, we want the project finished. We want the hospital built. We want our people to have access to hospitals. We want the schools built. We want our people to have access to education. So the bigger picture is, as professionals, we need to help our clients get the point of, okay, there's a dispute, let's comply quickly, put in our documents, we'll get our decision done out of the way. So that's what I would sort of say it's about for me. The bigger picture is, how do we as professionals get across the line? Let's use adjudication to achieve the ultimate end of getting our projects across the line, buildings, development. That for me is the bigger picture. So as lawyers, we then have the smaller bits and pieces where, you file your documents on time, you make your submissions. As an adjudicator, you sit quickly, give the parties a chance to be heard, make your decision. So that's, for me, that's the bigger picture ultimately.
Thank you very much, Joseph. And lastly, Albert, my question is, during involved giving visibility to these alternative dispute resolution mechanisms. And for me, my question is a practical one. How can we make adjudication more popular? And I'm saying more popular because often people confuse it with arbitration, or unfortunately litigation, and you find there is a contract that says, let's adjudicate this matter in the courts of Uganda. And so you get confused. So what are those practical tools that can be done to push this move for adjudication?
Thank you very much, Patience. I would think the first things first is to understand what construction adjudication is. And that means getting involved in some of the events like we have today that discuss construction adjudication in depth, but also going ahead to do further reading, trying to understand construction adjudication. And as a professional, of course, learning never stops. So it is important you get to know that how much do you know and how much do you need to know. And as you have seen, me and Joseph are lawyers. Charles is an engineer, but the discussion has been flowing perfectly because we have been able to appreciate the subject matter. So it means it doesn't, what that means is that it doesn't matter your background, as long as you're able to understand the principles of construction adjudication, then you should be able to apply them. And for the lawyers, Joseph highlighted the issue of making sure that the projects run. The starting point was construction adjudication is an interim dispute resolution mechanism. It should remain like that. It shouldn't be turned into either litigation or arbitration or even mediation, because it would cease to have its impact. So it is important that even when, as a professional, you get involved, either as an engineer, you are supporting the client, or a QS, or an architect, or a project manager, or a lawyer, because when it comes to the lawyers, and I think some of these institutions have tried as much as possible to try to limit the involvement of lawyers in the process, because sometimes the process is drawn out and it ceases to have the effect of an interim mechanism. But nonetheless, the lawyers are here to stay. Charles, that one, you know. But what the lawyers would be able to undertake is to make sure that, get involved in the process, understand why the time limits are very short, why certain things have to be done in a specific manner, and be able to come up with a decision that is both acceptable and enforceable within the parameters of the law. Yeah, so that would be my view.
Thank you very much, Albert. Very well said. So we have come to our end, the end of the webinar. But before we jump into the Q&A session, Charles, I would like you to give us your parting shots. And unfortunately, I am going to guide your parting shots because, we're trying to drive change and see better. And your last part, it's for me. The question is, in your opinion, and seeing that you discussed for us, the statutory framework of adjudication, do you think that African countries should adopt a similar regime?
Thank you. I think that, of course, it's funny how this same question is a question I answered in my master's. My master's research paper was basically about this. And maybe what I'm just going to say is my findings, so you can say I'm speaking with authority. So what I found out is that adjudication is much more effective as a statutory mechanism. Why? Because if it's not that, and it's just a creature of contract, then parties such as large employers like government, or even in instances where you're having foreign contractors and local subcontractors, they can maybe delete the arbitration. I mean, they can delete the adjudication clauses. In some instances, for example, FIDIC provides for appointment of DABs, of the dispute adjudication boards or the dispute avoidance and adjudication boards, 28 days after commencement. But I've been part of quite a number of disputes where it's 4 years down the road and that DAB was never appointed. And therefore, it actually defeats the purpose of a contractual adjudication regime. Although parties regard adjudication to be much more effective in comparison to, say, negotiation or mediation, which are much more used in the construction industry for obvious reasons, because of the fact that it can give a binding decision, though we've said that that decision can be temporarily binding in nature, it has been the case that adjudication has not been uniformly used or widely used in Uganda because of these issues. For example, I could ask how many private projects, apart from the public projects, how many private projects have you been part of or have you had that have an adjudicator on board or that use adjudication? And then we can also even ask about our adjudicator nominating bodies like UIPE, which has been a fixture on PPDA contracts since 2003 when the standard bidding document has been used. We do not even have statistics of the contract, how many adjudications they've done, nor do we even have literature about the same. So there could be a call for statutory adjudication. Of course, it can also be that we do not want to be drawn into some of the drawbacks it has suffered in other jurisdictions. For example, in the UK, it is now overly litigious. And therefore, one could say, why not just go straight for litigation instead of this stopgap measure? And of course, in an instance where we do not have a focused court, for example, in the UK, they have the technology and construction, the technology and construction court, the TCC that Albert had talked about earlier, that really only looks at construction disputes. In the event that now we are having our courts and the high court as it's set up in terms of the divisions it has, if we went to the statutory route, wouldn't we be shooting ourselves in the foot? Of course, there could be recommendations such as training, because one of the things I found out was that parties want to get engaged in adjudication, but they do not trust the adjudicators in Uganda because the adjudicators in Uganda have not been trained. They do not have sufficient training for the parties to have trust in the process. So one of those has to be trainings to adjudicators, trainings to the adjudicator nominating bodies. The other is a key thing that you mentioned earlier, which is enforcement. Enforcement of adjudication decisions had been a very lightly tested principle in our courts. It has been a very lightly tested principle in our courts, and that could be because of a number of reasons. But one of the issues could be maybe we have to sensitize the judges, because if you see how the enforcement is done in the TCC, the legislation actually had a loophole. The legislation did not provide for enforcement of adjudication decisions, the SGCRA, but the judges in the TCC, because they wanted to breathe life into the legislation, they found ways of enforcing decisions, and that was in 1999, and that way has stood and maybe been changed here and there, but adjudication decisions have been enforced since, I think, 1999 in the UK using that, and the legislation has not still, handled enforcement. It doesn't speak to enforcement. So it could be that we also need to sensitize our judiciary. We have to have trainings with them. They have to attend some of these things such that they get to know that some of these things exist. So if there is an adjudication decision made either by contract or by statute, then it should be something that they enforce. Maybe sensitization or things like that. But I think generally that, so it has its pros, but it also has its cons. So it depends on how we look at it and how we are able to deal with some of these things and also to apply them for our local context. Thank you.
Okay. All right.
Yep.
Thank you very much, Charles. Joseph, now I would like you briefly to tell us what are the things that that we can borrow from Zambia, or I know you've practiced in Kenya, you've practiced in South Africa. So what are some of the things that we can borrow to push for adjudication in light of the different forms that we are applying it currently, as your parting shot?
Okay. There wouldn't be that much to say because, really, Zambia is also a bit in its early steps, in terms of the adjudication space. It's a relatively new concept being introduced, and only because there's a realization that adjudication can help things move a little quicker in terms of the construction projects, which is why you've seen us then go towards statutory adjudication as well now. So if there is one thing maybe to take away is perhaps for Uganda to consider bringing it in as a statutory point of view, that is something perhaps to consider going forward. Okay.
Very much. And lastly, Albert, give us your parting shots in respect of the webinar for today.
Yes, of course, in the absence of the statutory regime, and of course, the most important thing is to push for it. But where it is not, then we have to rely on the tools that we have. That is, try as much as possible to rely on the contract-based adjudication provisions aligned with recognized standard forms such as the FIDIC contract, NEC, or JCT. Of course, include clear provisions on notices, referral mechanisms, appointment bodies, and the like. And most importantly, also ensuring that the appointment process is clear to avoid these cases of deadlock. Both Charles and Joseph have highlighted capacity building of stakeholders, because we could have the best law, we could have it in a piece of legislation, but if this is not disseminated to the people who actually would apply this process, then it would remain on paper. So it is important that the capacity building of all those involved in the process, the project cycle, is key, because it can only be a successful process if everyone knows what they do, what they have to do in an adjudication. And of course, enforcement is a key component of this. If it is non-statutory, then you rely on the authority of the courts, and the courts have to be proactive in this regard. Like I mentioned about the case in Botswana, the courts were quick to come in and enforce a DAB decision and a FIDIC contract. In contrast, there is a matter in Uganda, UNRWA versus TK and Bank of Uganda miscellaneous application number 756 of 2019, where a similar application was made to court to enforce an adjudication decision, but the court quickly said you could not smuggle an adjudication decision as if it were an arbitral decision for enforcement. So we, like Charles pointed out, trying as much as possible to bring this to the knowledge of the judicial system. Even in the English courts, as he pointed out, there was no similar power under the Act, but they were able to use their inherent powers. We have the Judicature Act, it could as well, and also the Constitution would as well be able to enforce these adjudication decisions under a similar framework. But nonetheless, I think there is a positive trajectory in terms of the growth of adjudication, not only in Uganda, but also in the neighboring jurisdictions. Like I highlighted, Kenya is adopting a statutory adjudication framework. I believe if it does,
Albert, I think we have lost you.
and it is successful, that the same will be adopted in Uganda.
All right, thank you very much. Thank you, dear panelists. You've been this has been a wonderful session, and I am certain that our dear participants have found this very fruitful. Unfortunately, we cannot exhaust everything in such trainings, and like the panelists have mentioned, it is imperative that we all continue to engage in these trainings and learn, learning does not end. So this is one of the many, and we have previously had others, and there will be more coming up. Now, would like to jump into the Q&A. We have some questions. Some are directed to specific panelists, so I'm just going to read them out. And Albert, I'm going to start with you. There's a brief one which says, does UIPE or the PPDA have adjudication rules to use?
Currently, there are no rules. The adjudicators rely on what they believe to be fair, and they rely on their expertise and knowledge to make a decision. Yeah.
Okay.
Maybe
All
if I
right.
can just chip in that even if you just do a simple Google search of, say, because as I say, UIPE should be held to a high standard because it has been an adjudicator nominating body for a while. But if you just Google UIPE adjudication rules, there's nothing that comes up. But then if you to Google Ciarb adjudication rules or UK adjudicators adjudication rules, those things come up. So all those, even now with that we have a contractual adjudication regime, all those are things that can be easily worked on to improve the practice of adjudication here.
Yeah. And then thank you, Charles and Albert. The other question, which I believe we have covered, one of Eugene was asking whether Uganda is considering a statutory adjudication anytime soon.
No, I don't think so. I don't think we have had such discussions because when I was in Lusaka, they already had the bill, and that was early this year. For Kenya, it has already gone through the second reading, meaning it probably needs one more reading and then assent by the president. So we're still lagging behind, but I think what we can do is now just to make sure that firstly, we get the contractual adjudication regime right, and then we can now move to the statutory adjudication regime. But I'm not seeing conversations regarding that. It would be interesting to go that side, but we've not yet had those.
Okay. Thank you, Charles. And then our other question is Ojambo Dennis asks that most adjudicators in Europe are quantum and delay. And he's wondering how best can we have such specialists incorporated into our construction industry, and specifically Uganda.
Yes, so I think the question he's asking is about the use of expertise, and this comes back to what we're saying, and maybe what Joseph said is that at the core of it, the adjudicator, one of the reasons that why the parties are appointing you is that you are an expert. But the challenge is how we are also trained here as engineers. So we are trained to be very technically proficient, but some of these things are not really things we are trained at school. And therefore one has to go out of their way to, have training in delay analysis, have training in quantum analysis, what are prolongation costs, what is involved, what are direct costs, what are indirect costs, things like that. So that could be a challenge, which is actually true. However, what we can do in the interim, adjudicators, even in the statutory adjudication regime, they have maybe one of their powers in the statutory adjudication regime is to appoint an expert, and the use of the expert is to help the panel. So even in this instance, it could be possible that adjudicators could get some of his expertise. They could request the parties that for this, in order for us to have, help, or in order for us to reach a fair determination, it could be important for us to have an expert and probably use some of his expert services. But at the core, as people, we also have to improve ourselves and try to make sure that we get some of these skills.
Well put. Thank you very much, Charles. This next question, I'm going to put it to you, Joseph. One of the participants is asking, what happens when the offending party, in this case, that's the respondent who was, taken to the adjudication, what happens when the offending party declines to pay their share of the adjudication fees? Over to you, Joseph.
So just the last part, I think you are broken when the offending party refuses to.
What happens when the offending party declines to pay their share of the adjudication fees?
I see. Okay. So initially, at least if I was sitting as an adjudicator, we wouldn't get to that stage because the idea behind when you're appointed as adjudicator, you need to agree your fees in advance. And leading up to the point when you're delivering your decision, you only deliver it when both of the parties have paid their fees. Okay. The idea being that you don't want to release it and then patient starts to refuse to make the payment, maybe because the decision is against her. So ideally, you would want your fees paid at the very beginning. Alternatively, we've seen scenarios where maybe one party is delaying in making payment. So the other party may say, okay, fine, I will make the payment of the adjudicator fee, but I'll recover it as a cost at the end of the process. So even if the decision is in my favor, I'll add it as part of the cost due to me. Or if the decision is not in my favor, and I'm the one who has to pay you something, I will then deduct it from the payment I'm making to you. But ideally, you would want your adjudicator as well as arbitrator, if you're seen as arbitrator, you'd want your fees paid before you release your decision or your award.
Thank you very much, Joseph. And I'm glad you've not experienced such scenarios where the parties refuse to pay.
Yeah.
Yeah. And now our other question, Regan is asking, he says he notices that there are no, the Building Control Act is silent on the adjudicator's qualifications. And his question is, what principles can be put in place to ensure that the adjudicator's independence and impartiality is handled in the absence of a statutory framework?
I think for this, one of the key things about being an adjudicator or even a third party neutral is that our stock in trade is the fact that parties should be able to trust us and make sure that that there are no bias allegations. Of course, when it goes to other instances, we have, say, IBA guidelines, because bias is an important issue. And one of the things, maybe when you're even accepting the appointment, is to say whether you have any relation or no relation. And of course, when you go to bias, then there's real bias and then apparent bias, and there are various ways case law has broken that down. So it would still be up to the parties to prove that you have bias, but normally you should be able to declare whether you have a conflict of interest or not. And normally about adjudicator qualifications, I still think that the way we look at adjudication in Uganda is a bit different from how the rest of the world looks at it. Simply because you're a chartered engineer in the UK doesn't make you an adjudicator. You have to undergo some of these other specialist trainings, like the ones offered by RICS, the ones offered by Ciarb, like by the Chartered Institute of Arbitrators, by UK adjudicators. It is through those that you're able to understand the law and practice of adjudication, because it's a bit different from being on site. And even if you are an RE, because if you're a resident engineer, then you're in ops all the time, you're writing letters and things like that, and you may not really be involved in the actual adjudication of disputes, or even how to deal with disputes, how to deal with issues regarding if a dispute has come up or not. So I still think that as Uganda, we still have enough time to really look at how the rest of the world is doing this. Simply because someone is a registered architect or registered engineer shouldn't really give them, or even an advocate of the High Court shouldn't really give them, the leeway to say that they are an adjudicator. They should undergo some extra training such that they are able to know how best the process goes on. It is only when that happens, and when we build a critical mass of people who have done that, that will be able to make people have trust in this process. And that is the only point where you say, now judiciary, listen to us. We are having a number of disputes that a number of us are resolving. And I think you guys will be comfortable with how we are resolving it and be like, oh, okay, then we shall be able to enforce your decision. So I think it is correct for it not to have qualifications, because I know how Ugandans will put the qualifications, but we can also move towards looking at what the rest of the world is doing, most especially if it's regarding building control. The English have really moved a really long way with the Defective Premises Act and their building safety regulations. So we have a lot to copy from. In fact, even Neighborhood Kenya here has a national building code that, really enforces building safety. So we can look at how they tackle it, and then we can also, try to come up with similar things or maybe similar things for our local context. Yep.
All right. And our last question is going to one of the participants. Spera would like to know. She notes first that there seems to be a thin line between adjudication and arbitration, since in both mechanisms, the parties are the ones who do the appointments. And her question is, why then go for adjudication instead of arbitration, since it has a legal framework? And also, how enforceable is the decision of the adjudicator? So there are two in one. Albert?
The question is a two-in-one?
Yes, so let me just rephrase for you so that you can first tackle the first one. She's inquiring why go for adjudication instead of arbitration. Yet arbitration has a legal framework and adjudication does not. So she wants to know what's the key difference between the two. Why adjudicate instead of arbitrate?
It depends on the industry, because for the construction industry, as Joseph noted, speed is of importance to us. So and also speed is of importance to us, flexibility is of importance to us. And then also maybe the fact that adjudication is still a little bit informal in comparison to arbitration. So we also still want that. And also the fact that it's private, given the fact that not many of you have seen the results of an actual adjudication decision. So adjudication finds itself in it finds itself in a position where it is much more used in comparison with, say, arbitration, even in the UK, where they have a statutory adjudication regime, because of the inherent benefits it has for the construction industry. So the construction industry is not going to, wait. So actually, one of the ethos of the adjudication process is pay now, adjudicate later. So parties can continue doing work, the project can continue going on, even as we are in the process of resolution of the dispute. It is that advantage that it has over arbitration that allows parties to actually choose it over arbitration as a means of resolution of disputes in the first instance. So we can say that even in countries like the UK, where they have a statutory adjudication regime, and they also have, arbitration as a creature of statute with the UK Act, we can see it that the parties still, because of trust in the process, the parties are still able to go for adjudication, and they are really comfortable with adjudicator decisions. They do not even proceed to engage arbitration or even litigation as a means of resolution of a dispute. So I think that would be my answer to that.
All right, thank you very much, Charles. One of the other questions, I'm going to address it. I've seen quite a number of questions that are asking how people can get more involved in the arbitration field. Now, the Chartered Institute of Arbitrators, the Uganda chapter, conducts several trainings, and there are also courses that are done by the chapter. If you're introducing yourself to arbitration, you would be able to do introduction to the arbitration training. You can find information in respect to these trainings and courses on the different social media pages of the Chartered Institute of Arbitrators. But also the other important thing I wanted to note is that CLI, the Construction Law Institute, also conducts trainings. It conducts trainings, and it also has a training in adjudication, but also it has developed rules for adjudication. There is a lobbying that is, underway on how to see this can be adopted, but they are available on the website. So I would encourage our dear participants to look out for these trainings by CLI, by the Chartered Institute of Arbitrators, by the Association of Engineers, Architects, Uganda Law Society. So there are very many opportunities for gaining the knowledge. And like the participants, the panelists have mentioned, learning does not stop. And the only way that we keep getting better and advancing in these areas of practice is if we equip ourselves with necessary knowledge, learn from different jurisdictions, and see how best we can improve ourselves to boost this area of practice. And also lastly, CLI, the Construction Law Institute, is a nominating body for adjudicators, and it also has a panel of adjudicators. So please don't be stuck with your adjudication disputes. Reach out to CLI. And we'll be happy to assist you. I happen to be a member of the Construction Law Institute. So there is a panel of well-trained, well-equipped and professional adjudicators that are able to handle these matters. As we come to the end of this webinar, I would also like to remind you once again about the upcoming the inaugural International Arbitration Conference. Please take advantage of the early bird rates. They are subsidized prices. We have shared the flyers and the details in the webinar chat. Please take advantage of them, register, come and learn, but not only learn, but get to network and meet the people in the different spaces, because we all know that the built industry, it cuts across. We have lawyers on this session. We have Charles is not a lawyer, but I think you have heard all the material that he's putting out. So come for the conference, let's network, let's build one another and continue to grow. I hope and believe that this webinar has been very insightful and that we'll put these principles that we have learned into practice and we'll build on them in our different areas of practice. Thank you very much for joining us today. I have been your moderator, Patience Akaprira, and I hope you'll join us once again once we call upon you to take part in these trainings. Thank you very much and have a lovely Friday and a lovely weekend. Thank you very much.
Thank you. Have a good weekend.
Thank you. Thank you, my dear panelists. You've been amazing. Well done.
All right. Thank you.
Thank you.
The Chartered Institute of Arbitrators, Uganda chapter. Well done. Thank you.